You're watching the legal breakdown. So, Glenn, we have the beginnings of what may very well turn into some nightmarish news for Donald Trump. The judge in the Fulton County case, that's Judge McAfee, he's placed a $200,000 bond on Trump, but it's the conditions of his bond that are especially interesting here. Can you speak on what those conditions are and what will happen if and when he violates them?
Yeah, let's be clear. This is the first gag order any judge has placed on Donald Trump. So in the order, it spells out in no uncertain terms that Donald Trump is prohibited from saying anything directly or inferentially that could be viewed as a threat, that could be viewed as intimidating of witnesses, of co-defendants. He is prohibited from posting or reposting anything that could be interpreted as a threat or as intimidating witnesses or co-defendants. That's pretty much the scope of what Judge McAfee prohibited Donald Trump from doing. How quickly will he violate these terms of release? Let's see, 3, 2, 1. I'm sure he's violating them as we speak. The real question becomes, once he violates them, what does Judge McAfee do? Does he give him additional warnings? Does he punish him? Does he step him back, so to speak? So that is really the question that I think we're going to be wrestling with.
Well, is the fact that we have these conditions clearly laid out, like, is that his first warning? Judge McAfee was very clear in his gag order. So does that mean that Trump won't be given a second chance if and when he does ultimately screw up?
It's a great question with no definitive answer. The reason I say there's no definitive answer, this is a very judge-specific area of the law. There is nothing that mandates that if you violate the conditions of your release one time, the following sanction must be imposed. Brian, I have had judges who are so forgiving that they would let a defendant violate conditions of release 2, 3, 4 times. And sometimes these judges believe that if they give the defendant a really stern talking to, the defendant will shape up and fly right. That's almost never the case. So this really is a decision that is unique to the judge. I can only hope that, in a circumstance like this, where Donald Trump has a demonstrated proclivity for reckless, dangerous, speech that incites violence among his supporters, that if he does something that directly violates the judge's release order, he will immediately be sanctioned. What might that sanction be? Well, unfortunately, it could simply be a fine. It could be, I'm going to set this for a contempt hearing, and you're going to have to prove to me why you shouldn't be revoked on release. Then they hold that hearing, and the judge says, okay, I'm not persuaded that you absolutely squarely violated my prohibition, so I'm going to give you one more chance. Here's what my gut is telling me. Donald Trump is going to get another couple of chances, and they're going to continue to give him enough rope. Goodness knows he has miles and miles of rope at this point. But I do think at some point, because Donald Trump is his own worst enemy and has no impulse control, he'll ultimately find himself in a place where a judge is going to say, listen, you have given me no alternative but to detain you pending trial, to revoke your conditions of release. That is where I think we are ultimately headed.
Can a judge in one case look at Trump's proclivity to violate the terms of his release in other cases and kind of let that influence how lenient or how strict they actually are? Like, can Judge McAfee look at Trump's willingness to violate Judge Chutkan's terms of release when he attacked Jeff Duncan and also attacked Mike Pence and say, okay, basically that's kind of your first warning, even though it didn't happen in this case? Or do they have to take their case solely in terms of what's happening right in front of them, and they can't take anything else into account?
So they can definitely take violations in other cases into account. And the way they'll take it into account is if, Donald Trump's lawyers say, well, what he posted wasn't really threatening or intimidating. The judge can absolutely look to his conduct in other cases to see if that defense flies. What a judge can't do is if a condition is violated in a separate case, but it doesn't actually violate the conditions, in the case in front of the judge can't use that other violation to revoke him in the case before the judge. So they can use it kind of as atmospherics, particularly on things like intent to violate. So I think that's what the judges will do. They will take it all in, but they will have to determine that, he violated a condition as set by that judge in that court before they can actually revoke him.
Okay. We've spoken a lot about the judges having a lot of discretion here. I want to be fair. If you're a judge, what are you weighing when you have a defendant like Donald Trump, who's a defendant unlike any other defendant, when it comes to pretrial detention? Because it really isn't exactly black and white here.
It's not black and white. It's all gray. So the two things that right out of the blocks will give the judge the ability to detain somebody pending trial are if the judge concludes by clear and convincing evidence, that's the evidentiary standard, concludes that the defendant is a flight risk, such that if released, the defendant will not return to court for the next status hearing or for his trial. Or if the defendant is a danger to the community, again, by clear and convincing evidence. And if he is, then the judge is authorized to detain him pending trial. Now, the landscape shifts a little bit once you are once you're a defendant in the case and the court starts setting conditions of release. When you begin to make it clear that you cannot or will not abide by those conditions, then that's where the gray comes in. The judge has to make a decision. Is it now so detrimental to the due administration of justice that this defendant refuses to comply with conditions or is unable to comply with conditions for whatever reason, that he needs to be taken into custody to sort of promote and preserve the integrity of the due administration of justice? But again, this is 100% gray. There's nothing black and white about these kind of determinations.
Glenn, talk about the $200,000 bond, because people are going to see that and say, this is a self-proclaimed billionaire insurrection leader. How is it only 200 grand? Why isn't it $10 million?
Yeah, the legal term that applies to the amount of bonds set in this case is whoop-de-doo. Okay, not exactly a legal term, but when I saw 200 grand to secure, his appearance at the next court hearing, I thought that was laughable. I thought it was actually kind of insulting for a number of reasons. One, he may not be a billionaire, right? He always overinflates his own net worth. Heck, he might not be a millionaire. He might be a thousandaire at this point, given all of his legal expenses. But what do we know? We know he will continue to grift his supporters to get that 200 grand and any other money he believes he needs. So I don't really understand what the principled reason was for setting a $200,000 bond, because that's chump change. I would have liked to have seen a judge say, if he believed the money bond was necessary, and frankly, I don't know that it was, the judge could have set a $5 million bond, a $10 million bond, at least make the point that if you're a self-proclaimed billionaire, well, I'm going to make you put some of your money where your mouth and ultimately where your freedom is in the event you violate conditions.
Well, do you think it's because he has the Secret Service with him at all time that he's not really a flight risk? So it doesn't matter if you make bond $100 million or $5. It's not like you're going to be able to escape the country when you have an entire Secret Service detail right behind you.
I do think it's unlikely that he could successfully flee the jurisdiction or the United States to a non-extraditable country, a country, that is where when people flee there, they're kind of beyond our reach. If we don't have an extradition treaty or agreement with a foreign country and there's somebody there who is wanted by the United States, it all comes down to negotiating with the local authorities in that country if you don't have an enforceable extradition agreement or treaty. So, but I don't think it's realistic that Donald Trump, with all of his Secret Service protection 24/7, would be able to successfully flee the country.
And I do have two questions about the Secret Service that I've gotten a lot of emails about. The first is, can you speak about what the Secret Service would do if Donald Trump were to try to flee the country?
Needless to say, there is no precedent, right? We can't look to an earlier example
Right.
of when a criminally indicted former president of the United States tried to flee the country. Here's what I'll say. I worked with the Secret Service, albeit the Secret Service Uniform Division, in any number of cases when I was a prosecutor in DC. You know, these are good, honorable, hardworking men and women of law enforcement. Not all of them. We have bad apples everywhere. But I absolutely believe that the oath they take, they swear allegiance to the Constitution and the rule of law, not to the President of the United States, even though their duty is to protect the President of the United States. I don't think they would be complicit, or they would turn a blind eye and allow Donald Trump to flee the country, in the event he's pending trial and was due in court, for example. So I have to believe their law enforcement instincts and the oath they took would kick in, and they would probably have Donald Trump sit tight to make sure he could appear at his next scheduled court date.
And the other question I had with regard to the Secret Service is, let's say Donald Trump does get convicted and sentenced to some degree of prison time. What does the Secret Service do during that time? I mean, are you going to have some Secret Service agent that's going to have to serve time with him in a jail cell?
Yeah, again, there's no precedent for this, but I've talked to friends of mine who are former Bureau of Prison employees, and I've talked to lots of U.S. Marshals, deputy U.S. Marshals, and kind of the conclusion that I've reached is that what would probably happen is the Secret Service would enter into an MOU, a memorandum of understanding, with the Bureau of Prisons and the U.S. Marshal Service. And together, those other two organizations, BOP and the Marshal Service, would essentially take responsibility for protecting the president while he is in the Bureau of Prisons. Now, the BOP has facilities with kind of general population, right? All of the run-of-the-mill federal convicts, but they also have secure facilities where we, for example, would house some of our cooperating defendants in RICO cases where there was a real danger to that cooperating defendant, but it was somebody who had to remain incarcerated pending their cooperation. And there are facilities where I am 100% sure Donald Trump could be placed, and they're run by the Bureau of Prisons, but the U.S. Marshal Service also has some of the protection responsibilities for those kinds of inmates in those kinds of facilities. They would be able to safely house Donald Trump while he served his sentence. But I do think the Secret Service wouldn't ultimately have any part of that once his custody was turned over to the Bureau of Prisons.
Okay, got it. And finally, let's end with this. One more question on the terms of Donald Trump's release for the Fulton County case. Do the terms of his release and this gag order apply for the entirety of this trial?
Yes. If he violates conditions of his release mid-trial, a judge could, and I believe would, sanction him, perhaps including revoking him and remanding him to custody. But here's the other thing. If he violates the conditions of release prior to trial, and it is such that the judge decides that his release has to be revoked and he has to be detained pending trial, that's pretty much all she wrote. It's not like if he is detained and he's a really good boy while he's being detained, that he doesn't violate any of the rules and regulations of the confinement facility. Somehow he's going to win his release again. Once you've been ordered detained pending trial because you are unwilling or unable to abide by conditions of release, that's pretty much it for the duration of the case.
Okay, well, we are on violation of terms of release watch then. I'm sure it could happen any moment now, like you mentioned before, if it hasn't happened already. So with that said, if you want to stay on top of this stuff, make sure to subscribe. The links are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.